മിസ്ബിഹേവ് ഇപ്പോൾ ഒരു ജഡ്ജിക്ക് ഒരു അലിഗേഷൻ വന്നു, അയാൾ ചീഫ് ജസ്റ്റിസ് ആയിരുന്ന കാലത്ത് വീട് ഫർണിഷ് ചെയ്യാനായിട്ട് രൂപ മുടക്കി. ദാറ്റ് ക്യാൻ ബി ടേക്കൺ as misbehavior and on that ground he can be impeached. So there is a provision that has been impeached and nobody has been so far impeached. Now you may see what is the procedure. They will ask you sometimes procedure for removal of judges. See, there is a Judges Enquiry Act. We passed an act called Judges Enquiry Act 1968. We passed an act called Judges Enquiry Act 1968. 1968 we passed a Judges Enquiry Act, and Judges Enquiry Act says how the judges can be removed. So what does judges say? It can begin either in the Lok Sabha or in the Rajya Sabha. A removal procedure can begin either in the Lok Sabha or in the Rajya Sabha. The rule is that it begins in the Lok Sabha, signed by 100 members. A notice should be given to the speaker. It begins in the Lok Sabha, signed by 100 members. It begins in the Rajya Sabha, signed by 50 members. A notice should be given to the vice president. President Lok Sabha തുടങ്ങുകയാണെങ്കിൽ 100 members should sign. And Rajya Sabha തുടങ്ങുകയാണെങ്കിൽ 150 members should sign. Notice should be given to the prospective presiding officer. Then he will appoint a committee. So speaker, if he receives a complaint, he will appoint a committee to inquire into this. And this committee will have 3 members. A 3-member committee is appointed by the speaker. Lok Sabha is speaker, Rajya Sabha vice president will appoint this committee. There will be 3 members. One, Chief Justice of India. Then another, Chief Justice of High Court, any High Court Chief Justice. Third is an eminent jurist. A 3-member body will be constituted by the vice president or the speaker. This committee will inquire into this. The committee will inquire into allegation. Suppose they find there is genuine reason for removal, then they will report. We can proceed with impeachment proceedings. Then Lok Sabha will start discussion. Then if Lok Sabha passes it by 2/3 majority, this will go to Rajya Sabha. Rajya Sabha must also pass it by 2/3 majority. Then the Chief Justice or judges stand removed. Now allegation is that Chief Justice of India, senior most judge will be in the committee. Naturally, the senior most judge will be in the committee. So if they recommend, they can be removed. When they are being removed, they have a right to defend. Judges can try to defend themselves. In the Lok Sabha as well as Rajya Sabha, they have a right to defend themselves. So they can engage a lawyer. With the help of the lawyer, they can try to defend. Judge. He can argue his own case. That is also permitted. And we try to remove 2 judges. The first case was Justice Ramaswamy. We tried to impeach a Supreme Court Judge, Ramaswamy. That failed. That was not passed. Then recently we tried to impeach Chief Justice of Calcutta High Court. We recently tried to impeach Chief Justice of High Court of Calcutta, Soumitra Sen. We tried to impeach Soumitra Sen. That also was not successful. Successful ആകാത്തതിന് കാരണം Soumitra Sen resolution was passed by Rajya Sabha. Then it must be passed by Lok Sabha. Soumitra Sen knew pretty well he will be impeached before the Lok Sabha. Resignation. We can simply say he has resigned. We cannot say he has been impeached. So we try to impeach 2 judges. Ramaswamy's case, Lok Sabha, he was to be impeached. And Ramaswamy was from Tamil Nadu. But Jayalalitha was in power in Tamil Nadu. Congress party was in power at the center. These 2 parties had an alliance. But Ramaswamy impeached on the bomb. Jayalalitha will say Congress side varnu. He is from Tamil Nadu. Please see, he is not impeached. I will impeach him, but Jayalalitha coalition partner. Congress party was in a dilemma. Congress party varnu. Yes. When his impeachment proceedings put to vote, all Congress party members will abstain. Abstain required majority there, and therefore he could not be removed. So Soumitra Sen case, he could have been removed, but he resigned. So there is a procedure for impeachment of judges. And the parliament passes, then president will issue an order removing him from service. If that order is issued, he is removed from service. Then salaries, another important point in Mr. Salary of a judge can be increased by the government. Normally it cannot be reduced. Government has the power to increase. What the constitution says, it should not be altered to the disadvantage, means it can be increased only, government cannot reduce. But when there is a financial emergency in operation, the salaries of judges can be reduced. That is the only situation when the judge's salary can be reduced. When India is having financial emergency, salary of a judge can be reduced. But when the emergency is lifted, he must be given the original salary. Aduvare atra naale reduced salary can be given. But we cannot speak anything from experience. Etra samanan korakadu varayan pattilla because we have so far no financial emergency. So that is a provision. These are all provisions to make the judges independent. Another is Supreme Court judges cannot practice as advocate after retirement. A Supreme Court judge after retirement cannot practice in any of the courts of India. He cannot practice in any of the courts of India as advocate. He is an expert in law. Ranjan Goi, Bobbler retired. They are experts in law, but they cannot practice as advocate. But no bar, they can have employment. They can get jobs, they can get assignments under government, and they can do that. But only thing, they cannot come and practice in a court. But let us say Ranjan Goi retired. Next day he comes and practice in the Supreme Court. He is to practice before his subordinates. That is not fair. Then a returned judge could be influenced by some parties. ഒരു വിധി പ്രസ്താവിക്കാൻ പോകുമ്പോൾ ആ രാജിവെക്കാൻ ആ കക്ഷികൾ വേദിക്കാൻ പറയും ഏതായാലും പോലെ ഞങ്ങൾക്ക് അനുകൂലമായിട്ട് വിധി തരിക, നിങ്ങളെ ഞങ്ങളുടെ വക്കീലാക്കാം, അങ്ങനെയൊക്കെ ടെംപ്റ്റേഷൻ ഉണ്ടാകും. സോ ദർ ഇസ് എ റൂൾ ദേ കനോട്ട് പ്രാക്ടീസ് ആസ് അഡ്വക്കേറ്റ് ഇൻ എനി ഓഫ് ദ കോർട്സ് ഇൻ ഇന്ത്യ. വാട്ട് അബൌട്ട് ഹൈക്കോർട്ട് ജഡ്ജസ്? ആഫ്റ്റർ റിട്ടയർമെന്റ് they cannot practice in the same high court. They cannot practice in the lower court. They can practice in other high courts where they have not worked, or they may go to Supreme Court of India. Avarku Supreme Court va, or they may practice in other high courts, but not in the same high court they have worked. But Madrasil Keralathil irunal rendu high court lo practice cheyan pattathilla, but they can practice in other high courts where they have not worked, or they may go to the Supreme Court of India. But they will get assignments. Lot of assignments are given to the retired judges, because some posts are reserved for retired judges to Supreme Court. They alone can hold a post. Human Rights Commission and post both for judges to Supreme Court. Law Ayukta Keralathil retired Chief Justice can be appointed. Law Commission retired judges can be appointed. Qualification പറഞ്ഞില്ലെങ്കിൽ പോലും Governor Justice Sadashiv was the Governor of Kerala for 5 years. Formerly Justice Fatima Bibi was judge of Governor of Tamil Nadu for 5 years, 3, 4 or 5 years. So judges get assignments. Lot of assignments are there. Lot of commissions are also appointed. A Supreme Court may appoint some this commission, and the retired judges are given this commission. That means they will be engaged, they will get salary, but only bar they cannot practice after retirement. So Supreme Court judges cannot practice after retirement. And Supreme Court has the power to punish for contempt of court. If anybody disobeys order, anybody criticizes order of Supreme Court, they can be punished for contempt of court. Marriage issue was there. Marriage, the Supreme Court ordered marriage flats should be demolished, but Kerala government did not take any step. Then Supreme Court took the contempt of court case against the Chief Secretary, and he was asked to come before the Supreme Court of India, and they could proceed further. Anybody who disobeys order of the court, who criticizes the judges, can be punished for contempt of court. So the Attorney General should be qualified to be a judge of Supreme Court. Jurist അല്ലായിരുന്നു വക്കീലായിരുന്ന ആൾ തന്നെയാണ്, അതിൽ അപ്പോയിൻമെന്റ് തടസ്സമൊന്നുമില്ല. അറ്റോർണി ജനറൽ സുപ്രീം കോടതി ജഡ്ജ് ആകുന്നതിന് കുഴപ്പമില്ല, ബിക്കോസ് ക്വാളിഫിക്കേഷന് പറഞ്ഞിരിക്കുന്നത് ഹി ഷുഡ് ബി ക്വാളിഫൈഡ് ടു ബി ജഡ്ജ് ഓഫ് ദ ഹൈക്കോർട്ട് എന്ന് സുപ്രീം കോർട്ട് എന്നാണ് പറയുന്നത്. So he can be appointed as judge of Supreme Court. There is no more. He is well qualified. And at this level, central level, they appoint only very eminent persons as Advocate General. All important cases of central government are to be argued by. ഇല്ലെങ്കിൽ നല്ല വക്കീൽ എന്ത് ചെയ്യും? ഈ 103 സിറ്റിസൺ ഇപ്പോഴത്തെ ബില്ല്, ജമ്മു കാശ്മീർ ഇഷ്യൂ, ഇതെല്ലാം സുപ്രീം കോടതി ആരാ ആർഗ്യൂ ചെയ്തത്? അറ്റോർണിയില്ല. അതിൽ മിടുക്കനല്ലെങ്കിൽ എന്ത് പറ്റും? ഗവൺമെൻറ് ഇതിലെല്ലാം പരാജയം. സോ എമിനന്റ് ജഡ്ജസ് ആർ എമിനന്റ് പേഴ്സൺസ്, എമിനന്റ് ലോയേഴ്സ് ആർ അപ്പോയിൻറ്റഡ് ആസ് അറ്റോർണി ജനറൽ. ദേ ക്യാൻ ബി ഡെഫിനറ്റ്ലി അപ്പോയിൻറ്റഡ് ആസ് ദേ ആർ ക്വാളിഫൈഡ്. പക്ഷേ പലപ്പോഴും ഏജ് ഇതൊക്കെ പ്രായം കഴിഞ്ഞവരായിരിക്കും. സുപ്രീം കോടതി ജഡ്ജാകാൻ 65 വയസ്സാണ്. ഇപ്പോഴത്തെ വേണുഗോപാലിന് 80 വയസ്സ് വരെയുണ്ട്. അപ്പോൾ 65 വയസ്സ് സുപ്രീം കോടതി ആകാം. അതിലും കഴിഞ്ഞാൽ ദേ ക്യാൻ കണ്ടിന്യൂസ് അറ്റോർണി ജനറൽ. ആരായിരുന്നു ഫസ്റ്റ് അറ്റോർണി ജനറൽ ഓഫ് ഇന്ത്യ? MC സെത്തൽവാഡ്. M.C. Sattalbot was the first Attorney General of India. Qualification is, it should be qualified to be a judge of the Supreme Court. ഈ മൂന്ന് ക്വാളിഫിക്കേഷൻ ഏതെങ്കിലും ഉണ്ടെങ്കിൽ he can be appointed as Attorney General of India. So these are the, then content of court. Content of court also you must study. We have passed an act called Content of Court Act 1971. We passed a new law, Content of Court Act 1971. Content of Court Act 1971. Content of Court Act divides contempt into two. There are two types of contempt. One is called civil contempt and the other is called criminal contempt. Contempt of court. Civil and criminal. There are two types of contempts. One is called civil contempt and the other is called criminal contempt. What do you mean by civil contempt? Civil contempt means disobeying the order of the court. Somebody disobeying order of the court is civil contempt. Chief Secretary does not follow the order of the court. That is civil contempt of court. What is criminal contempt of court? Criticizing the judges. Criticizing judgment is criminal contempt of court. So we classify contempt of court into two, civil and criminal. Chief Secretary does not implement the order of the Supreme Court, civil contempt. കുറച്ചാൾ മുമ്പ് കേരളത്തിലൊരു പൊളിറ്റീഷ്യൻ ഉണ്ടായിരുന്നു. ഈ ക്രിട്ടിസൈസ് ജഡ്ജസ് he called him ചുംബന്മാരെന്നൊക്കെ പറഞ്ഞു. ദാറ്റ് ഈസ് ക്രിമിനൽ കണ്ടന്റ് ഓഫ് കോർട്ട്. ബട്ട് ഫോർ ബോത്ത് പണിഷ്മെന്റ്, മാക്സിമം പണിഷ്മെന്റ് is same. For both criminal and civil contempt, maximum punishment is 6 months simple imprisonment. 6 months simple imprisonment and or a fine of 6 months simple imprisonment and or a fine of rupees 2000. 6 മാസം വരെ തടവ്, അല്ലെങ്കിൽ 200 രൂപ പിഴ, അല്ലെങ്കിൽ രണ്ടും ആകാം. 6 months സിമ്പിൾ 2000 രൂപ പിഴ, അല്ലെങ്കിൽ രണ്ടും കൂടി. 6 months imprisonment, simple imprisonment and or a fine of rupees 2000 rupees fine vare. That is the punishment for contempt of court. Many judges have been punished. Now judges have been punished, former judges have been punished, IAS officers can be punished, anybody can punish for contempt of court. For example, Kerala High Court, the Chief Secretary order കൊടുക്കുന്നു. He does not obey it, he can be summoned by the court, he can be punished. Some days you can be sent to jail also. First of all, they will you tender apology, that may be accepted. But continuously violating, definitely you will get punishment. So that's the power of the court, it can punish for contempt of court. And by these provisions, we make the Supreme Court independent. It is completely free from any kind of interference on the part of the legislature and the executive. President appoints the judges. After that, he has no control of the judges, and he has no right to criticize. Even the Parliament members have no right to criticize the judgment judges. Parliament members have maximum freedom of speech and expression, but even then, they have no right to criticize the judges or judgment. എന്തു പറഞ്ഞാലും I say judges can be criticized. എപ്പോഴാണ്? Only one occasion when the judges can be criticized. പാർലമെന്റിനെ ജഡ്ജസിനെ ക്രിട്ടിസൈസ് ചെയ്യാൻ ഒരു അവസരം മാത്രമുണ്ട്. എപ്പോഴാണ്? ഇംപീച്ച്മെന്റ് പ്രൊസീഡിങ്സ് ആർ ഗോയിങ് ഓൺ. അറ്റ് ദാറ്റ് ടൈം ദേ ക്യാൻ ബി ക്രിട്ടിസൈസ്ഡ്. അല്ലെങ്കിൽ പ്രൂവ് ചെയ്യാൻ പറ്റത്തില്ലോ. ദേ ക്യാൻ ക്രിട്ടിസൈസ് ജഡ്ജസ് ജഡ്ജ്മെന്റ്. അതർവൈസ് നോ ജഡ്ജ് ക്യാൻ ബി ക്രിട്ടിസൈസ്ഡ്. ഇപ്പം അമ്മാരുടെ ഫ്ലാറ്റിലേക്ക് ഉണ്ടായി, ശബരിമല ഇഷ്യൂ ഉണ്ടായി. Whatever be the decision of the court, that cannot be criticized in the parliament. Parliament members cannot criticize the members, the judges or the judgment. Even Prime Minister has no right to criticize judges' judgment. They have a big power, contempt of court case can be filed. But normally we see many people criticize. Even the channel you can see, many people come in the channel and simply criticize judges. They know pretty well, court will simply ignore. കോടതി എന്തിനാ ഇതൊക്കെ പറയാൻ പോലെ? 8 മണിക്ക് ചാനലിൽ പറയുന്ന 9 മണിയാകുമ്പോൾ ജനങ്ങൾ പോലും മറക്കും. പിന്നെ ഇതിൻ്റെ പേര് കണ്ടന്റ് ഓഫ് കോർട്ട് കേസ് എടുത്തിട്ടെന്താ? ദാറ്റ് ബൈ ഗവൺമെൻറ് സിംപ്ലി ഇഗ്നോർ. അപ്പോൾ ഇവർ നോക്കുന്നത് ദേ ട്രൈ ടു ഗെറ്റ് പബ്ലിസിറ്റി. സുപ്രീം കോടതി ഇന്നാക്കാരെ കേസ് എടുത്തു നോക്കുമ്പോൾ ദേ ഗെറ്റ് പബ്ലിസിറ്റി. ആൻഡ് ഈവൻ ഇഫ് എ കേസ് ഈസ് ഫയൽഡ് അഗൈൻസ്റ്റ് യു, ഇഫ് യു ടെൻഡർ അപ്പോളജി ദാറ്റ് വിൽ ബി അക്സെപ്റ്റഡ്. അപ്പോൾ പിന്നെ കേസ് എടുത്തിട്ട് ഒരു കാര്യമില്ല. അതുകൊണ്ടാണ് ഈ ചാനൽ ഇങ്ങനെ വന്ന ഒരുപാട് പേര് ക്രിട്ടിസൈസും നോർമൽ. അതേ സമയത്ത് VIPs വലിയ പ്രധാനപ്പെട്ട ആരും ക്രിട്ടിസൈസ് ചെയ്താൽ definitely contempt of court case can be taken. So these are the methods to protect the independence of Supreme Court. Now what are the powers Supreme Court? Supreme Court's power.